Well, legal practitioner Olutekunbi joins me live as we explore this issue. Well, legally speaking, does Goodluck Jonathan, having taken the oath of office twice as President of the Federal Republic of Nigeria, have the law's backing to seek re-election as President?
Well, good evening. Thank you for having me. The provisions of the Constitution, the 1999 Constitution of the Federal Republic of Nigeria, as amended, clearly prohibits a candidate for taking an oath of office twice with respect to the office of the President and the Governor of the states. Therefore, it is my very humble opinion that President Jonathan, having been sworn in twice, first as a president that succeeded the late Yaradua, and also subsequently to have been elected as a full-time president, has taken an oath of office twice. Now, what people are saying, or what the law even provides, is that in jurisprudence, law does not apply retroactively. But there are a lot of exceptions to that. The question to ask is that, what is the applicable law as of today in Nigeria? Can a politician have a law different from other contestants who, if a law is of a general application? Will you now say an individual is an exception to a law that has a general application? My answer will be no. Therefore, I believe very strongly that it will be unnecessary waste of time if an unnecessary attempt to probe or to provoke a constitutional crisis. If you look at what happened with Ayedatiwa in, I think in Ondo State, the court has been very explicit that it can no longer recontest the office of the governor of Ondo State. Having been sworn in the second time, recall that he was sworn in to complete the terms of the late governor that died, and he has now been elected as a governor. So I believe the President Governor Jonathan is not constitutionally eligible to contest, you know,
wow.
And whether the law will apply to him retroactively or not, which is what he believes, that the law does not apply retroactively. Yes, that's the principle of law, that a law cannot apply retroactively. But where a law is of general application, are you going to exempt him from the condition that other candidate is going to be subjected to? The answer is no.
I hear you on that. And, you know, he has actually said he will now consult widely before he makes a decision. But how do you see that consultation go? And how do we reconcile this pressure by loyalists and political gladiators, you know, to vie for office? How do we reconcile it with the realities on ground and what the polity is saying?
Well, the reality on ground is that he doesn't have much time to consult. Because first and foremost, he has to make his intention known. The INEC has a timetable for doing of both nomination forms, submission of nomination form, and expression of interest. So if he's consulting, he should consult widely. But I believe President Goodluck Jonathan haven't been given the position of an elder statesman now. So he should just relax and watch and advise. I don't think he should subject himself to unnecessary political quagmire.
Legal practitioner Olutekunbi, thank you so much for your time on TVC News at 10.
Thank you for having me.